Hello friends, welcome back in our YouTube channel Indus Lex. From today we are going to initiate the lectures on Indian Constitution because to achieve the mission of Indus Lex, it is very necessary that every citizen of this nation should know the core values and principles enshrined in our constitution. And for this purpose, we are taking several initiatives, and one of them is we are trying to promote constitutional values through education of constitutional principles. What is written in our constitution, we will start from the preamble of the constitution itself, which is a goal setter and a key for understanding the mind of our constitution makers. So without wasting time, if you have a bare text of the constitution, you should, and almost everyone has seen the preamble in their textbook, in their several competitive books, and it is a very easily available on internet, that the preamble of the constitution. Preamble of the constitution starts from the word we the people of India, meaning thereby, if a question is asked that from where the Indian constitution derives its authority, it is the constitution. Constitution derives all the authority from the people of India, that is we. We, the people of India, having solemnly resolved to constitute India into five types of state, that the Indian state must have these five characters, and these five characters are sovereign, socialist, secular, democratic, and republic. Sovereign, socialist, secular, democratic, and republic. Here, it is important to note down that the word socialist and secular is not there at the time of enactment of this constitution. It is inserted in our constitution by the 42nd amendment of the constitutional amendment 1976. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic, and republic, and to secure to all its citizens one justice, and justice is of three types: social, economic, and political. Meaning thereby, our constitution, which derives its authority from we the people of India, and it try to make and try to establish a state which called India, that is Bharat, as per Article 1 of the Constitution. So we the people of India are making the India state as a state which is sovereign in nature, socialist, secular, democratic, and republic. Further, the goal of the Indian state is to provide and secure to all its citizens justice, which is of three types: social justice, economic justice, and political justice. Apart from justice, it our constitution, preamble of the constitution talks about liberty. Liberty of what? Liberty of thought, expression, belief, faith, and worship. After justice and liberty, it also talk about equality of status and opportunity, equality of status and of opportunity, and to promote among them all. To promote among them all means between amongst the citizens of Indian state. To promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. Again, here the unity and integrity of the nation is substituted unity of the nation by the Constitution Amendment 42nd, 1976, meaning thereby the preamble says that we, the people of India, going to make a nation which is sovereign, socialist, secular, democratic, and republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all the fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In last, in our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give ourselves to this Constitution. Meaning thereby, Indian Constitution is adopted by us on 26th November 1949, and as we know, on 26th January 1950, this Constitution come in the force. Further, when there is some interpretation going on in the Honorable Supreme Court, the two cases is very important at the initial stage. We will discuss several case laws on this channel, but in initial stage, the two case law which is very important. It is important because a question is arose that whether we can amend whether we can amend in the preamble by using article 368. Article 368 provides power and procedure of the amendment in the constitution, meaning thereby if our parliament following the procedure mentioned in the article 368 can parliament has power to amend the preamble of the constitution. At that time, in the Berubari Union case, year 1960, Honorable Supreme Court said no. By using the power prescribed under Article 368, Parliament can only change in the constitution, not in the preamble. Meaning thereby at that time, Honorable Supreme Court held that preamble is not the part of the constitution. It is something like that. Of there is a book, there is 17 chapters, and there is a provision that if a person is aggrieved or necessity otherwise require, some people having power can change or alter or amend anything within the constitution from chapter 1 to 17. Maybe this is, but if there is some notes, some preface, some index that generally not come, or we can't consider that the content is actually the part of books. And in the same manner, Honorable Supreme Court interpreted the Constitution and preamble of the Constitution. Honorable Supreme Court held that from Article 1 to Article 395, this is the Constitution, not the preamble. But when in Keshwanand Bharti case is come before the Honorable Supreme Court, and at that time it was discussed and it was brought in notice in the Honorable Supreme Court that the parliamentary debate at the time of Constituent Assembly during the making of this constitution, this Herculean task, it was pointed that although the preamble is at very beginning of the constitution, before article 1 to article 395, preamble is there in the constitution, but it started very early stage but finished in very last, meaning thereby the last part which is finalized by our constituent assembly is the preamble. Why it is done so? It is because preamble must be consistent with the values enshrined in Article 1 to Article 395 of the Constitution. And with this respect, Honorable Supreme Court in the Keshwanand Bharati case, and remember this case is a very landmark and the superior case in the constituent history of India, because it is only the case which is dealt by the 13 judges bench. It means in the Indian history, this case has the largest bench, that the bench of 13 judges. And the bench of 13 judges are deciding what is the scope of Article 368, how much the parliament has power to amend the constitution, whether the parliament has amending power which is of unlimited nature, whether parliament can amend anything in the constitution what they want. Answer given by the Honorable Supreme Court by 13 judges bench in Keshwanand Bharati case is very clearly said that no, it is not possible. There is some basic foundation on which our constitution is living. Our constitution is an organic document. It is a legal living document which governs the whole administration of our nation. And our constitution makers on 26 November 1949, when we, the people of India, hereby adopt ourselves to this constitution, at that time there is some foundation, there is some values, there is some morality on which this constitution is based on. And therefore no such values, no such principles, no such provisions can be amended by using the power under Article 368, because once the Constituent Assembly dissolved, the complete changing power is finished, because now the Constituent Assembly is no more. Today the Parliament is using the power of Constituent Assembly. So the question is whether the Parliament has the same power which the Constituent Assembly has at that time. Answer given by the Supreme Court is no. Today's Parliament cannot amend anything by using Article 368 of the Constitution. And in the same manner, and what is the touchstone? How do anyone examine whether this amendment is within the four corner of the Constitution, within the limitation of the power under Article 368? Honorable Supreme Court said that we will examine on the doctrine of basic structure, meaning thereby by using Article 368, anything can be altered or amended in the Constitution by using Article 368, but not the basic structure of the Constitution, not those principles on which our Constitution is based on. What is basic structure? Basic structure are those values and principles which is enumerated in various provisions, such as we are democratic nation. By using the power under Article 368, no parliament can pass such amendment in the Constitution which says from today we will not be a democratic country. We say we are republic country. Maybe parliament passed such law and said that from today we are not going to be a republic. It is not possible, because it is a basic structure It is a basic foundation that we initially said that we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic, and republic, can, by using power under Article 368, Indian state can lose its sovereignty? Can we say that from today India will be the dominion of Britain or America? Is it possible? No. Parliament has no such power. At the time when these discussion is going on, Honorable Supreme Court said that whatever issue may become, we will test whether it is violation of basic structure or not. Now, we have to understand that whatever the constitutional law, suppose that a law is passed, we will discuss it in Article 12 and 13, how the constitution governs the law making process. Article 13 says no law which is in force before the commencement of this constitution would be null and void to the such extent which is violative of this constitution. Meaning thereby if any law which was in force before the commencement of this constitution would become null and void if it violate or inconsistent with any provision of the constitution. And further it directs no legislature or authority makes such laws which is inconsistent with the constitution. But if Parliament using Article 368, the power of amending the Constitution, which is a very vast power, that Parliament can amend the Constitution. This on when the Parliament use this power and amend the fundamental right or amend the procedure established by Article 368 itself, it should be it should be judged on the basis of basic structure. But if any ordinary statutory law is passed by the Parliament, the touchstone to check that this is constitutional or not constitutional is only that whether it is violative of any rights or any laws provided under the Constitution. But when it comes about the amendment under the Constitution itself, it would be only tested on the basis of basic structure. We will meet in another session. Thank you.